Hello, my name is Polli. I'm a partner and head of the family team at Pinney Talfourd Solicitors. I'm joined today by my colleague Surjit Verdi. Surjit, what's your role within the family team?
Thank you, Catherine. My role is a senior associate in the family team, and I undertake work including divorce, complex financial remedies, cohabitation, prenuptial agreements and Children Act work, amongst a few of the areas.
I understand that you actually deal with quite a lot of blended families as well, is that right?
That's correct.
Explain to us what's a blended family.
A blended family is one where there are two parties in a relationship, so they can either be married or living together, and what they've done is they've formed a new family. So often they'll have children from previous relationships or marriages, and they're now all living together as a new family. And it has practical and legal considerations, which I know we're going to be talking about today.
So the situation is complicated. What are the legal considerations that people need to think about?
So they would need to think about step-parent parental responsibility. So that is when a parent would acquire parental responsibility for the child or children that are within this family. And parental responsibility will allow that person to make decisions about schooling, health, education. That can be acquired through agreement with other parents with parental responsibility, or it can be through a court order. But what we would try to do is try to get that through agreement. They've also got to think about contact arrangements with the other parent and how that's going to work with this new family, and importantly thinking about how they're going to deal with their financial aspects and how they're going to share their assets. A lot of the time blended families are second marriages, or they've been in relationships where they will be bringing assets into that relationship, so they might want to protect those assets for their own children.
So that's key, isn't it, actually, to blended families? It's this interaction of finances together.
Together.
The situation with the children is complicated enough, but when you get into finances, it's even more complicated. What's the advice then you give to clients around should they marry or should they cohabit?
The law is very different for married couples or cohabiting couples. If you marry and you separate, the starting point for the division of assets is equal. With blended families, they may not want an equal division of assets because of the fact that they have bought assets in from previous relationships or marriages, and they want to protect that for their children. So they've got to think about what they could put in place in those circumstances.
There's a lot of talk at the moment about prenuptial agreements, and if those parties are going to marry and there is a blended family in place, is a prenuptial agreement something they should think about, and what sort of advice would you give to a client?
Yes, it is definitely something they should think about. So a prenuptial agreement is a contract that they would enter into, and what that agreement would do was set out how they would divide their finances in the event of a separation. But what they have to think about is that a prenup has got to be fair to both parties. So a prenup cannot just provide for one and not provide anything for the other. It needs to provide for both, but at the same time, if they're bringing assets in, a prenup can provide to ring fence, separate those assets, or decide how jointly owned property is going to be divided between them upon a separation.
Thank you. So definitely something they need to think about.
It is definitely.
But maybe not for everybody.
Yes, correct.
What if they're going to cohabit?
So it's absolutely crucial that if parties are going to enter into a prenuptial agreement, that they take independent legal advice.
Thank you. What about if they're going to cohabit? The situation's different, yes?
The situation is very different. It is a myth that a cohabiting couple are like husband and wife. That is not the case. A cohabiting couple do not have the same rights as a married couple. So in the circumstances of a blended family, if a party are moving in together, or a party is going to put the other person's name on the title deeds, they really need to think about how that property is going to be held. So if they're going to buy a property jointly, they would need to think about what contributions they're putting into that property. They might want to hold it unequally, in which case they should have a declaration of trust drawn up. It's important to note that if you put a party's name on the title deeds, say for example of a property that one party already owns, the other party will acquire an interest in that property automatically. So it's very important to make sure that advice is taken when you are moving in together or purchasing a property together.
Cohabitation agreements, that's something that we talk a lot about with clients. Do you think that's important for clients, whether or not they're actually going to legally or equitably own the property together? So perhaps even if they're in rented, is a cohabitation agreement something they should have?
It is important to have a cohabitation agreement drawn up if you are living together, because it can avoid any disputes in the event of the relationship breaking down. And the advantages of having a cohabitation agreement is that a cohabitation agreement can include things such as how the property is being held, whether a party is going to acquire an interest, how the parties are going to divide their finances, how they're going to meet their outgoings. It can even go as far as if you wanted to including any details about any children that you may have. So it is important to think about having a cohabitation agreement drawn up, or at least having legal advice as to whether it would be a benefit to the parties.
Thank you. So probably the most important of all then is to take advice around that cohabitation agreement and then look at the property aspects as well.
That's correct.
Finally, the one thing that we both tell clients all the time is make a will.
Yes, they would definitely need to make a will, because their will is going to then determine what would pass depending on how the property is held.
Great. Lovely to chat to you today. Thank you.
Thank you.